William, do you mean to tell me that a will is not the best option when it comes to estate planning?
No, it's a basic document that everyone should have, at least have a will. But a trust is a more powerful document that allows you to have more decision-making powers in your estate.
William Bustamante is a local real estate attorney here in Miami who specializes in estate planning. I thought he'd be a wonderful guest to be able to share some great insight and knowledge that he has with regards to his profession. Today, we're going to be discussing common questions that he gets and that also I obtain from my clients. And I thought, what a better platform than to put it out to share with our audience on, again, these typically asked questions. So, and that is the perfect segue, William, to what's better, a will or a trust?
Okay, that's a personal decision between individuals. Okay, everyone should have at least a will. A will outlines, includes all of your property and outlines how you want it to be distributed upon your death, etc. A trust, on the other hand, allows you to make decisions as to your distributions, etc. during your life. Okay, you can maintain control of it. You don't. It becomes effective as soon as you create it. Okay, it allows you to make distributions during your life. Say if you have you want to distribute some assets or income to a minor child or to a school age kid, etc. You can make distributions. You can make instructions in it as to when you want to make distributions upon them, a portion of distributions upon them reaching 18 years of age, 21, 25, 26, etc. Partial distributions, etc. It allows you to name a guardian if you become incapacitated, okay, without having to go to the court to open a guardianship, which is a very costly procedure. It also avoids probate costs that you have to undergo when you only have a will. All right. You also have a will. You can have a will with a trust. It's called a pour over will. In other words, but this will is simpler. It makes the beneficiary of everything that you own the trust, and in the trust you hold all the powers and you make all the decisions. Okay. You have you name a trustee and a substitute trustee if you wish. That has to be an individual who you wholly trust. The initial trustee would be yourself so that you can maintain control while you're alive. Okay. It's got to be someone who you trust wholly. In other words, the substitute trustee. It's a very powerful document. You can do many things. You can buy and sell properties during the time that you're alive. You can also maintain the homestead exemption of your homestead residence if you place the proper language in the transfer documents. To be effective, though, you need to fund the trust. Funding the trust means you have to transfer title of your properties into the trust. Okay. And for this, you need a trust attorney to make those documents for you. Okay. It takes it's a little costlier than a will, but in the long run, it's a lot more effective and a lot less costly than going through a whole probate process.
So it may be, as they say, right? It's probably a bit more of an investment up front as opposed to the tail end, because on the tail end through probate, it could be substantially more. And in the segment that you just mentioned, William, you said a few things and I thought I would just point them out. Probate. If you wouldn't mind explaining, what exactly is probate?
Okay. Probate is the legal process by which, the court, confirms the will that let's say someone dies with a will. The will, you have to go find an attorney to open a probate process for you so that the heirs can acquire the property that was devised to them. Okay. It's a lot of paperwork. You submit that to the court. You have to make a publication in a local newspaper for a period of 90 days to allow any creditors to make their claims. After the 90-day period, then during this time, the judge, the judicial system confirms, reviews your will, etc., in order to make sure that it was done properly, that there's no fraud involved, that everyone who was entitled to, as a beneficiary, has been given the opportunity to challenge it and to confirm it, to confirm the facts in it. It's a long process. Okay, it's a long and costly process. It takes from 6 months, can take from 6 months to a year to 2 years to 3 years, depending on whether there are any claims against the estate, etc. And you have the opportunity to challenge them during this period of time. And finally, the court will issue orders based upon the information provided to the court. Okay, it's basically the court acts as a guardian of the estate. They have to confirm that everything that has been provided has been done correctly and that the proper heirs are taken care of. That's the probate.
Right. And I appreciate that explanation, right? So the way that I view it, if I were just to summarize it, a probate is a legal process on determining, right, who is entitled. If there's a creditor, if somebody steps forward and says, I'm a relative,
Right.
They have a claim, they say that they have a claim, right? That's that process. I personally have experienced probate in my own family to where the expense of the probate, I want to say, was at least $35,000 and probably a year and a half of going back and forth. It was extremely stressful. And if a trust would have been properly executed, it really would have made the world of a difference. And going back to what you were mentioning earlier about homestead exemption, I think we need to touch on that because I think the impression from the public is if a property is transferred out of an individual's name into a trust,
Right.
into a corporation, into any other entity, that they may lose homestead. So if you wouldn't mind just recapping on if the person would lose their homestead exemption, which is the discount on their property taxes, by changing it to a trust.
Right. If you transfer a property into a corporation, etc., you will lose the homestead exemption, definitely. However, if you transfer that property into a living trust, as long as the proper language is included in the transfer document, the deed, the quick warranty deed, the quitclaim deed, etc., you can, here in Florida, you can maintain your homestead exemption. Obviously, you always want to verify if the property is being financed with the lender. Just confirm with them that they won't have any issues with this, etc., or they may have some specific requirement. But generally, you can maintain your homestead exemption in the state of Florida by transferring it to a living trust.
That's a very big deal. With regards to what's on a trust, can the PR, right, personal representative, or the trustee,
right,
can they do anything that's contrary to what was established in the trust?
Well, it all depends. The initial trustee will be you, the property owner. So you, as
let's say that person passes.
If that person passes, generally the trust will become irrevocable at that time. You have to make sure that language is included in the trust. Sometimes there's an allowance when it's a married couple and all the beneficiaries are their own kids, etc. Out of that particular marriage, then you may allow your spouse to have those decision-making powers to make any changes, etc. But normally it becomes irrevocable, and you have to make sure of that, especially when you have different family members, prior marriages, etc. It's very important to make sure that it becomes irrevocable upon the death of one of the trustees.
That makes complete sense. Now, I've heard the term trustee and PR, personal representative, used almost interchangeably.
Right.
What's the difference with the trustee and with the personal representative?
Generally, in a will, the manager, the person who carries out your wishes, is called the personal representative. In a trust, it's called the name that we go by is the trustee. Okay, their functions are basically almost the same. Okay, it's a manager of your estate, is what it is.
Got it. It's the person that's overseeing the wishes of whether it's on the will or from the
let's say it's
trust.
like the CEO of a company. they're the ones that carry out your wishes. Make sure that your wishes are carried out.
You also said something about a substitute trustee. The substitute trustee is who falls in charge, who falls into place if
the initial trustee,
the initial
dies or becomes incapacitated, etc. Then you can name someone who, obviously, these are individuals who you have full trust in, you know.
So the trustee, while they're living, they have full control. And I've heard the term living document used when it comes to a trust. If you wouldn't mind just going into a bit more detail with regards to why this is considered a living document.
Okay. Basically, it starts with a will. A will does not come into play until after the individual dies. That's when the will needs to be recorded in court, and it speaks for the deceased. Whereas a trust, from the minute you create it, it's active. You can you have decision making powers with it. You can buy and sell properties. You can you can do many things with it. Okay, say including if the trustee becomes like I was saying before, becomes incapacitated. Okay, you can make medical directives in it. It has the trustee can have the powers as in a durable power of attorney. You name someone who will act as your guardian, okay, to make medical decisions on your behalf, etc., without having the need to open a guardianship. In other words, it's a document it's working. It's like having a corporation. It's active while you're alive. You don't have to wait until you die. And then upon your death, you can leave instructions as to how things will be carried out, whether all the assets are to be distributed immediately upon your death or in partial disbursements. Say if the beneficiaries is a minor, etc. Well, you might not want to distribute it to them until they reach a certain age or accomplish certain things, and you can make partial distributions upon different ages, etc. You can make provisions in case you have a child with some special needs. You can have the trust create the trustee be responsible for creating a special needs trust to make sure that a child with limitations, health limitations, is taken care of, or an individual, or an older person, etc. You can make many things. It's like I've said various times, it's a very powerful document you can use for many things.
And my take on it is sometimes people think that a trust should be created later in one's life, right? And I'm of the belief that the sooner you do it, the better. And as time, since it's a living, breathing document, that you make additions, right? And you continue to purchase property if you're looking to purchase multiple properties in the name of the trust.
Yeah, definitely. First of all, we have no guarantee as to how long we'll be alive. Okay, you make plans and God makes decisions. A trust, you can, by the way, you can say, if you're an investor, you can own. Generally, it's advisable to buy properties, investment properties under an LLC, a corporation, etc. You can do certain things with the corporations, making the trust the owner of those corporations. Okay, there are different ways of doing it. Once I'm in a one-to-one meeting with my clients, I'll advise them as to what's the best options to do in certain scenarios. It also allows you, by the way, it's very important that trust will allow you to place properties which you may own in different states. All states have different probate requirements, etc. And if you die owning properties in different states, you will have to open a probate in different jurisdictions, etc. When those properties are under the name of a trust, it's a lot more effective, and the trust can avoid all those requirements of opening probate actions in different states, which is it ends up being very cost effective too. And it's a very good way of managing all of your properties.
And as we're having this conversation, what's going through my mind is it possible for, let's say, like a primary residence where the person is financing?
Okay.
I need to ask my lender, and if anybody's hearing this, obviously you can please comment down below. If it's possible for somebody to purchase a primary residence property where the property's in the name of the trust, or does it have to be in their name personally?
That could be complicated. Before actually entering into the transaction, I would consult with the lender to see what their requirements will be, etc. And that way, don't wait until the last minute. So if you have a trust or are planning to create one and are in the process of buying a property which you intend to finance, I would speak with the lender first, see what the requirements are. Maybe you should create the trust after the purchase, or you have to, provide the lender with some specific guarantees, etc.
Correct. And not that I mean to get this deep into that specific question. However, let's say that, for example, the typical conventional guidelines, right, whatever it is, Fannie, whatever guidelines do not allow for the property to be in the trust. There are relationships with local banks, maybe credit unions, where they would allow the trust to be, as far as to the name, the property to be in the name of the trust versus a typical conventional type of loan. So that's something that, again, somebody who's looking to purchase properties in the name of a trust, they may want to have those conversations, find the right outlet first, and then use them for the financing. For sure. Regarding estate tax, so if somebody inherits a property, I'm not sure if you can answer this question or if this is more of a CPA question.
I prefer to stay away from that. It's basic answers, yeah, but when it comes to taxes, I prefer a tax expert to deal with those things.
Okay, so maybe when we meet in the future next time, William, what we'll do is that we'll create a third little window and we'll plug the CPA in there so that they can answer these types of questions with regards to tax, right? Because I know it's obviously a concern if someone inherits a property, if they have tax or not. I'm not sure if it has to do with price points and all of that stuff, but I guess that's where the CPA would kick in. So with regards to this, whether it's a trust or a will, some have asked me, is this a public document? Is that something that's recorded in the county records?
Okay.
Is it private or public? Is that inside of their safe, their attorney's safe? I mean, where is this, secret document?
Very important. Okay. When you have a will becomes, upon your death, once it's recorded in probate court, it becomes a public document. Okay. Remember, an inventory has to be made of your properties, etc. And basically, the public has access to it. You can either individually or through a probate attorney who can get into the docket of different cases and see what's there. When you have a trust is a private document. Okay, what you have to do is a declaration of trust or a certification of trust has to be recorded in the public records, giving notice to everyone that a trust is in existence and that this such and such individual is acting as the trustee and that can be contacted, etc. Okay, but the information in the trust, the assets that you have, that is private. That is not, the trust itself is never recorded. It never becomes a part of the public records. Okay. That's an instrument that you should keep in a safe place, whether a safe place in your home, etc., or in a safe deposit box at a bank of your choice, etc. It is a private document.
So, will is public upon the person passing away. A trust remains private.
Right. And for an individual, say, who has, the more assets you have, the more you might want to keep certain things private from even from family members, from business partners, from different individuals. It's private. It's your property. Why have everyone take a look at what you have and what portion of it you're giving to someone or not? I would say it creates jealousy. It avoids jealousy, conflicts, etc. It's That's a good point for having a trust also.
Correct. And if it's a public document, the will, it could be messy, right? I mean, everyone pretty much knows what they're getting or not getting,
Right.
and I could see how that
Right.
could definitely
It could
go
be. It
sideways.
doesn't mean that it is, but it could be. It's a matter,
And I do
it's a
like the
matter
fact that
of choice. It's an individual
correct,
choice.
and the trust is always private. So I've seen in movies when the person passes, then you have the attorney that's in their office, and they have that huge bookcase behind them with all of the books, and then they take out the little envelope. And they, break the seal and they say, you get all of this, and then the other person gets all of that. It's great for TV.
Great for TV.
And I'm
it's
sure
Hollywood.
it's great for TV. The reality is, like, what is the protocol, right? So the person passes away. There's a trust drawn up. There is an attorney that has this trust. Is the attorney keeping tabs on the individuals that they've done the trust for, or checking up periodically to see if they've passed? I mean, and I know it's a little bit technical, but I'm just curious on when the person passes, what are the next steps?
Not really, accepting, with individuals who have a huge amount of properties, etc., and they might place the attorney in charge of certain things. But normally, it's the individual who you have named as the trustee, substitute trustee, or the personal representative, the closest family member. They're the ones that keep tab, and once the person passes away, they reach out to an attorney who they trust to handle the estate for them and advise them and counsel them as to what are the proper steps to be taken.
So let me see if I'm understanding that answer. So the person passes, the trustee would typically step forward, right? And say, because they'd have the documentation, this person has passed, we're going to execute the documents. We're going to fulfill the wishes that are on the trust.
Right. They will visit an attorney, a probate or trust attorney, and and discuss with them and get advice as to what are the steps to be taken, how everyone who has an interest in the estate needs to be notified, etc. Those are the steps, basically, the initial steps to be taken.
So it really would be any type, not any type, but it'd be an estate planning attorney.
Right.
It doesn't necessarily have to be the same attorney who drew up the trust.
No. It can be an attorney of your choice.
And then that attorney would be basically fulfilling the wishes of whatever was on the trust.
Right. Making sure that the steps are outlined in the trust are followed. Yeah.
And what happens if the trustee, what was the name? The substitute trustee. What happens if the substitute trustee is no longer alive? How would
you have to? Okay, if there's not a second substitute trustee, etc., you have to contact the closest family members, and they'll have to come to a decision. Most likely, they'll petition the court to name. They'll petition. Someone will come forward and request to be named as a trustee. They have to get approval by all the beneficiaries as to someone who they feel comfortable with acting as the trustee or the personal representative. So there you have to involve the court in that situation.
Correct. Would that technically be considered a probate?
Not necessarily. It's you might have to open the probate just for the purpose of getting a substitute approved by the court. Okay. Not go through the whole process. It's just for the purpose of naming a substitute to handle the estate.
So the trustee passed. The substitute trustee is no longer with us. If that were the case, how would anybody know that trust even exists? The original trust that was drafted, that was drawn up. How would anybody know that trust exists? I'm not sure if
Well,
I'm not trying to throw a trick
that
question
can
at
be
you.
iffy. That's a matter of whoever prepares a trust, letting your closest family members know that there's a trust, and allowing them, or letting them know where it's kept, etc. Whether it's at a local bank, or at a specific location. So that can be a little difficult, but it's a matter of a little investigative work has to go into that.
And I say this in my ignorance, right? Not
No,
really
no,
knowing
no.
exactly
It
how
affects us all.
how the system works. My suggestion, not knowing anything about this, would be as if an attorney drafted a trust, that there be somewhere a public notice that John Smith, drafted a trust for Michael Gonzalez. That's public notice. Not necessarily what's on the document, but just providing notice.
That's what I mentioned earlier. That's why a declaration of trust or a certification of trust needs to be recorded in the public records upon creation of the trust, letting the world know who's the trustee, etc. And if something like that happens, you start by looking for that, finding that individual, etc., searching the public records as to where the property is, etc., and searching. I mean, you got to do your investigative work.
It makes the goose chase a lot easier.
And start.
Right?
You might need to get a private investigator to find out who the heirs are, who the closest relatives are, etc. Okay.
Right. That's on the heir side. I'm saying as far as to the tracking of the documents. You said that there's a declaration of trust. Yeah. So that's recorded. That's standard procedure. Maybe that's the piece, the component that I was missing.
Right.
So when the person does the trust, there's a recorded document stating that they have a trust. Am I understanding that correctly?
Yes. Now, the location of the original trust, that's the other question. You have to, if you own the trust, you have to let your closest trusted individuals know where it's located, etc. Possibly having someone keep a trusted individual keep a copy of it, because the problem comes if no one can find that trust, then you have to open a civil action to allow a court to decide what's going to happen, and you may possibly have to go through a regular probate process then in that case. But that's getting far off.
All right, it's a much smaller, lesser probability.
Yeah.
And I get this question, William, I'm sure you do also.
Which one?
Is if there isn't a will or a trust, does the government keep everything?
Not necessarily. Well, it could, but if a person doesn't have a will or a trust, then distribution has to be made according to state law. Okay, the state will act as basically the guardian of your property, and it has its own family tree. Okay, and it'll make distributions according to that. To the closest relatives will get the largest. Will get options to obtain the properties, etc., according to that family tree. If they cannot locate anyone, it has to go through a process. An attorney ad litem will be appointed by the court to search for relatives. If none are local, then nationally, internationally. At the very end, normally there's always someone will be found, whether they're hiding somewhere in the forest in Alaska or somewhere. If at the very end no one is found, then in that circumstance, yes, the government will end up with it. But that's unusual, but it does happen.
And I'm asking this out of curiosity. So the tree would be children,
spouse and children,
grandkids. Well, that's right. Spouse,
children,
grandkids,
your parents. No, spouse,
parents.
Children, your parents. Then it goes to brothers, sisters, cousins, first cousins, second cousins, etc.
So the order would be first spouse, right? Spouse, kids,
Yeah.
grandkids, then parents?
Yep. The main thing is to, if you make estate planning decisions, the earlier you make them, the more you're actually helping your family members, those individuals or charities, organizations who you want to help out. If you keep waiting on until later, you feel you're too young, etc. And a lot of people, a lot of us are guilty of that. Okay, we keep on waiting. We think, well, we're too young, we can't make those decisions, etc. If something happens to you, you're leaving your loved ones with a lot of problems, a lot of decision makings, a lot of chaos. Uh, Conflicts come about. There's people close to you or friends, etc., who would be the rightful heirs to certain properties, etc., who you're leaving them with with a a messy situation, and that can create a lot of family conflicts. Okay, whereas if you leave everything outlined exactly, it makes it a lot easier for those who you care for. Or it can be individuals, like I said, it could be organizations, charitable groups, etc. It's a good idea. If you really care about those around you, you should take care of your estate planning for your family.
And what I've seen is that the older someone gets, right? And when I say older, I mean older, the more difficult the conversation becomes to have with them. So if the person does it earlier in life, they're just assets.
Yeah. And
right? They're just assets. And
remember, if you make it early in life, as your financial situation changes, you can always amend those plans. It's not ingrained there that you can never make changes. While you're alive, you can amend it, change it as many times as you want to. But start with something.
And that's where the living document, comes in,
right?
That you can keep making changes to it as time progresses.
Of course, yeah.
Thanks for joining me in my conversation with William Bustamante. His contact information will be in the description. Comment down below on any takeaways that you had, or maybe there was something that you would like to have heard more of. If you enjoyed this content, I would immensely appreciate if you could like and subscribe to my page.